Thanks to CuriosityStream for keeping Legaleagle in the air.
Whoa, did somebody say lawyer? Richard A. Bottomfeeder, attorney at law.
I take exception to that. Lawyers are not bottom feeders, even when they are literal bottom feeding fish. Hey Legal Eagles, it's time to think like a lawyer, and today we are covering the highly requested episode of SpongeBob SquarePants, Krabs vs. Plankton. This will probably be the last cartoon I cover for a while. You can check out my breakdowns of The Simpsons and South Park down in the description below. I thought it would be fun to end with an example of maritime law, and SpongeBob SquarePants technically qualifies.
I surrender!
Be sure to comment in the form of an objection, which I'll either sustain or overrule, and stick around until the end of the video where I give SpongeBob SquarePants a grade for legal realism. So without further ado, let's dig into this episode of SpongeBob SquarePants, Krabs vs. Plankton. Okay, so Plankton is going to the Krusty Krab in order to steal the recipe for the Krusty Burger. Wait, no, that's The Simpsons.
Go!
He's going to steal the recipe for the Krabby Patty. Okay, that's it. The Krabby Patty, which is probably some sort of trade secret in the same way that Kentucky Fried Chicken is a trade secret or Coca-Cola is a trade secret. But I'm guessing Plankton probably does this on more than one occasion, kind of like Wile E. Coyote.
That was easy. Maybe today is the day I'm gonna steal the Krabby Patty formula!
All right, a classic slip and fall case. There is an entire genre of lawsuits devoted to exactly this kind of thing, this kind of personal injury, because it's so easy to fake your injuries like this. So this is the kind of thing that gives lawyers and lawsuits a bad name.
Look at you, Plankton. Once again, you're falling flat on your back in another pathetic attempt to steal me formula. Though you tried and tried, you haven't had the smallest nibble of my delicious formula. And you never will!
I mean, the guy has already injured himself. There's no reason to be mean to him and taunt him when he's on the ground. Not a good idea for a restaurant owner to be that malicious.
How do you sleep at night knowing you're a complete failure?
There really should be a wet floor sign.
Yeah, if that were me who slipped, I'd sue old man Krabs for all he's got.
You know, that's a very good point. There probably should be a wet floor sign in the vicinity when someone is mopping up the floor. Although, query how you can mop up a floor and have standing water when you're literally under water in the first place. Putting that aside for the moment, I think these patrons are absolutely right that there should be a wet floor sign in the vicinity.
Does that include the Krabby Patty formula?
Of course.
Oh, the pain! I can't feel my arms and legs! I think they're broken!
Do Plankton have arms and legs?
My pain and suffering!
Sue!
Oh, that looks bad.
Uh-oh.
Poor little man.
Oh, hold up a second. Plankton, we don't need to drag this little incident into court, do we?
Well, if you transfer the Krabby Patty formula to me, I'll forget your gross negligence.
Scoundrel! You'll have my formula when you pry it from me lifeless claws!
Yeah, so this is actually based off of the real-life case of Whelan versus Van Natta, where someone went to a shop legally, but then snuck around in a private residence that was attached to the shop. The issue at hand is the question of being an invitee versus a trespasser. An invitee is someone that is there for regular business purposes, and a trespasser is someone who does not have permission to be on the premises. And generally speaking, a landowner must act as a reasonable person would toward invitees. And to figure out what a reasonable person would do, you look towards others who are in exactly the same place. Given that we see wet floor signs just about everywhere, you can bet a reasonable restaurant owner would probably put one out if they were mopping the floor. Or they probably wouldn't leave standing water in your restaurant in the first place where people can trip and fall. Now, with respect to trespassers though, a restaurant owner or a landowner doesn't owe the same duty of care. Basically, if someone is trespassing on your property, your only obligation is to not hide dangerous things or create dangerous situations on the premises, like a guy who created a shotgun booby trap to punish people who were breaking into his house. Mwahaha! You know, what's really interesting about this particular case is that California did away with that invitee trespasser distinction and replaced it with a sort of general reasonable person standard. In the case of Rowland versus Christian, the invitee trespasser distinction was found to be unhelpful by the court, and the court just held that the landowner owes a duty to act as a reasonable man, now a reasonable person, in sort of general. So it doesn't really matter what the status of the person who is injured on the property is, you just always have to act as a reasonable person. Mr. Krabs has not put out the sign that says there's a wet floor, and so he's probably liable under the California standard.
See you in court, Krabs! I mean, oh, the pain! The deep frying pain!
Now, of course, Plankton is malingering here and he's faking all of his injuries, so that sort of shows you that he hasn't actually suffered any damages here in this particular case, and he's really perpetrating a fraud on both Krabs and the court. But sometimes you can have a court case where you're entitled to $1 in damages, because I think Krabs may have been in the wrong to not have a sign out with respect to everybody else. And so Plankton fell, he just didn't really have much damage as a result of that. So he might be entitled to what are called nominal damages, and a jury might end up awarding him $1 instead of the millions in the recipe that he's actually seeking.
I'm in a blue ruin. I'm doomed.
Don't worry, Mr. Krabs. I will do whatever it takes to keep the Krusty Krab formula from getting into Plankton's evil hands.
What I really need is a good lawyer.
Whoa, did somebody say lawyer? Richard A. Bottomfeeder, attorney at law.
I take exception to that. Lawyers are not bottom feeders, even when they are literal bottom feeding fish.
I couldn't help but notice that despicable display.
So, how much is this gonna cost me?
Actually, I won't charge a dime unless we win.
Yeah, that's a pretty standard thing for a plaintiff's attorney to charge, and especially in a personal injury lawsuit because of the risk, and generally speaking, if you're a plaintiff in a personal injury case, you probably don't have the fees to pay someone hundreds of dollars an hour to represent you. So a plaintiff's lawyer in this particular situation would probably ask for somewhere in the neighborhood of 35 to 50% of any recovery. While it sounds like a lot, the lawyer is actually in a precarious position where, number one, the lawyer might not recover anything, and number two, the lawyer has to front a lot of the court fees and court costs that go along with a lawsuit, which can add up pretty quickly.
In fact, I think we should countersue for everything Plankton owns.
So that is kind of a real thing. You are allowed to countersue. Generally, what people do is they file what are called compulsory counterclaims. So they are things that arise from the same set of facts. And here, Krabs doesn't really have any compulsory counterclaims. There's nothing that must be brought at the same time that results from the same nexus of facts that the lawsuit arises from. The opposite of that is a permissive counterclaim, which you can bring in the same action or you can bring it whenever you want because it doesn't really relate to the claim at hand. And that's what this lawyer is asking to bring in, is whatever past deeds have happened, there is some efficiency gained because you're already hashing out this claim against the same party. But courts don't really like permissive counterclaims because it really multiplies the number of things that they have to deal with.
Oh, Mr. Krabs?
What is it, lad?
I thought you might want to hear my testimony for when you call me as a character witness. I've been rehearsing it.
Actually, SpongeBob, we won't be needing any testimony from you. Why, you'd be more of a liability than an asset.
Yeah, and also you wouldn't really have a character witness in a slip and fall case like this anyway. Character witness has no bearing on whether negligence has occurred here, whether there was a duty, whether there was a breach of that duty. There's no reason you would complicate things, and it's a good idea not to call SpongeBob SquarePants to the stand.
But
run along, make things shipshape for my victory celebration. I've got to get to the courthouse early. There's only a few free parking places.
Oh, this is gonna be a slam dunk.
Oh, no! Mr. Krabs' lawyer, speak to me!
Wrapped with pain.
So sometimes this does actually happen. Sometimes the lead trial counsel is rendered incapacitated and you have to pick up with somebody else. In fact, when I interviewed my friend Brent Wisner, who was the lead trial counsel in the Monsanto Roundup cases, the original lead trial counsel, who was slated to handle everything, was injured in a windsurfing accident just weeks before trial. So he had to pick up on the eve of trial and handle the whole thing himself before he got a $2 billion verdict. So it does happen from time to time.
I'll give you one last chance. I'll drop the charges if you give me the formula.
Never, you little whelp!
Ow, ow, my little arm!
What? No! I didn't lay a claw on him!
Ow, my other arm! Ow!
He's lying!
I will say this is a little ridiculous. It doesn't make any sense that Plankton would actually fight Krabs. I don't think Plankton actually even have arms, and I don't even think Krabs and Plankton interact with each other in the ocean anyway. If only there were a biologist that could rank these animals in some sort of a tier.
Ocean-dwelling crabs and zooplankton interact quite frequently in the reef meta. SpongeBob's plankton is most likely based on the species of plankton called the copepod, a microscopic animal that's actually in the same subphylum as Mr. Krabs, since they're both crustaceans. Similar to how those battles are depicted in the show, one-on-one it's really no contest. Crab builds that use the filter feeding ability actually directly target plankton mains as their main source of XP. So yeah, as it turns out, SpongeBob's depiction of the one-sided rivalry between Mr. Krabs and Plankton is actually fairly reasonable. If you're interested in what the tier list for the rest of the Bikini Bottom residents looks like, be sure to check out my channel after you're done here.
Huh, well that's good to know. Thanks, TierZoo. Now let's get back to the trial.
Mr. Krabs, where is your attorney?
I don't know where he could be.
Here I am!
Thank you for joining us, Mr.
SpongeBob LawyerPants, Your Honor.
Yeah, that is the unauthorized practice of law. You are not allowed to represent other people if you have not gone to law school and passed the bar. And SpongeBob would face serious repercussions from pretending to be a lawyer right now.
What are you doing here, SpongeBob?
Your lawyer, fell down on the job. But don't worry, Mr. Krabs. I have everything under control. It's, all in here.
Really?
Yep, right?
Yeah, that's not gonna end well.
Is there a problem?
Your lawyer didn't give me the combination.
Is the plaintiff ready to proceed?
Yes, Your Honor, I'll try. Ow, 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 ow.
Although it's very sympathetic, I really would not counsel Plankton to represent himself here. He would do much better to have an actual lawyer to represent him instead of doing everything on his own. That doesn't tend to end well for people.
I wasn't always the tortured shell of a protozoa that writhes in pain before you today. I was a vibrant, carefree, happy-go-lucky single cell.
Pull yourself together, boy.
Then came the fateful day that I paid an innocent visit to the death trap known as the Krusty Krab.
Not a bad opening statement so far. I kind of like it. Very persuasive and definitely hits on some good emotional beats.
Upon entering said establishment, I found myself without any warning, slipping and finally falling onto a hard, unforgiving floor that had been intentionally covered with a viscous fluid.
You know, he's a little bit over the top here in this opening statement. It doesn't actually matter if Krabs intentionally put the water there or not. Certainly, if he did intentionally put the water and tried to hurt some people, then that would be far more than actual negligence, and that would border on an intentional tort. But just the fact that he was careless and did not do what a normal restaurant owner would do would be enough to be guilty, or in this case, liable, for negligence.
Where was I? Oh yeah, but the worst part is my dreams of completing a marathon like I promised my old Grammy have been dashed. I'm sorry, Grab. I'm sorry. Thank you for your kind attention, suckers.
Does the defense have an opening statement?
Yes, Your Honor. Poor Gram!
I probably don't need to tell you that that is a terrible opening statement, and they would have done better to reserve their opening statement and give it at the start of their case in chief after the plaintiff is already gone. Yeah, so far SpongeBob not doing a good job. And by the way, it shows how important preparation is before the trial itself. They've done no discovery whatsoever. They just went straight into trial and they haven't even been able to open the briefcase that contains their entire defense.
Mr. Krabs, can you identify this item?
It's a wet floor sign.
Do you own one?
No, I don't.
I gotta hand it to Plankton. That's a great question to ask on cross-examination. Assuming that Plankton knows that Krabs does not in fact own one of these signs, that is probative to the case at hand. It helps demonstrate his negligence, that by the fact that he doesn't own the sign, he couldn't put it out, and the sign potentially would have prevented his injury in this particular case. Good cross-examination. Well done.
No, you don't understand. I had to make some tough business decisions, and the sign seemed superfluous.
Yeah, I don't think that matters.
No more questions.
Your witness, Mr. LawyerPants.
Yeah, I don't know if Plankton should have stopped the cross-examination there. He could have gotten some other good points. But I also don't think Krabs' defense that he doesn't have the money for the sign would hold any water. Here, if you're not financially able to have a sign that is sort of necessary for all restaurants and stores to have, odds are you probably shouldn't be in business. So I don't think that's a good defense to the fact that he did not own and did not put out this wet floor sign.
May it please the court, ladies and gentlemen of the jury, my client has been called cheap, miserly, and chronically tight-fisted.
This is not relevant and not helpful.
As cheap as the prosecution claims he is, would he be able to sit there quietly while I took out $1 and dropped it in the blender?
Oh boy.
Daddy's got you. Daddy's got you. Daddy's here.
Yeah, so in addition to showing that SpongeBob did no preparation in terms of preparing his witness and defendant for actually taking the stand here, he's also asking questions that are in no way relevant to the case at hand. Whether or not Krabs is cheap in general does nothing to address the fact of whether he committed a negligent act in the first place, except to the extent that Plankton has already done to show that Krabs didn't own a sign and therefore he couldn't put it out, which definitely does go to negligence. So SpongeBob not doing a great job here. He's arguing against his own client.
Does the defense have any witness to call?
Yes, Your Honor. Defense calls Squidward to the stand.
Squidward, a loyal employee.
Mr. Squidward, is it? My client has been called cheap. Would you agree with that ludicrous statement?
Yes.
You know, again, this has no relevance, and the last thing you want to do is try to show character here when it's not relevant to the case at hand.
Can you tell the court of some instance of Mr. Krabs' generosity in any way?
Nope. Can I go now?
Generosity not relevant.
So, it was you who made the floor slippery, wasn't it? Answer the question! Need I remind you that you, sir, are under oath?
I don't know how you put him up under oath, but yeah, he would be under oath.
It's just his lunch. Or is it?
Defense calls Plankton to the stand. Why did you go into the Krusty Krab that day?
Ah, that's a really good question. That would definitely help his case if Plankton actually answers truthfully here.
To, say hello to my once good friend, Mr. Krabs, what?
Are you sure it wasn't to make off with one of these?
Aha, getting to the heart of the matter.
Gotcha. Weren't you there to steal the formula of the most delicious, sweet-smelling sandwich known to Bikini Bottom? Krabby Patty.
I can't take it! Gimme! Yippee!
Well, he didn't really answer the question, but he did show that he was faking all of his injuries, which probably is not going to be good for his particular case. But interestingly, as we established, putting aside the fact that Plankton totally faked all of his injuries, it depends on the jurisdiction. If they were in California, I think arguably Krabs was probably in the wrong. If we're in most states, however, Plankton was in the wrong because he was a trespasser and not an invitee.
Has the jury reached a verdict?
We have, Your Honor. We find the defendant not guilty. But he is cheap.
So this is a civil case. Civil cases don't decide guilt or innocence. Civil cases decide damages and who's liable and who's not liable. So The jury would not decide that Krabs was not guilty. They would decide that he was not liable and owed no damages.
I made you a present.
A present for me?
Close your eyes and hold out your hand.
Yeah, you're
It's a wet floor sign. I made it myself.
Well, it'll do.
It's better than nothing, I guess. Okay, so now it's time to give this episode of SpongeBob SquarePants a grade for legal realism. On the one hand, you have a really interesting fact pattern that is clearly based on real-life cases and deals with real issues like the standard of care that is owed to people that are on your property and whether someone is an invitee versus a trespasser. On the other hand, you have some unauthorized practice of law, you have an abbreviated time period, and you have some ridiculous interspecies fighting and fraud on the courts. But all in all, I'm pleasantly surprised at how much realism they were able to squeeze into 10 minutes. So I'm gonna give this episode of SpongeBob SquarePants a C+, specifically a pineapple under the sea.
I am now going to assault your mind with subliminal messages.
Now, this is not the first time that TierZoo and I have teamed up. In fact, we actually helped build a platform for creators so they don't have to worry about things like demonetization. It's called Nebula, and we're partnering with CuriosityStream. As you may know, some friends and I recently launched our own streaming service called Nebula, featuring lots of YouTube's top educational-ish creators, including Polyphonic, Knowing Better, Wendover, Lindsay Ellis, 12 Tone, and of course, TierZoo. We get the freedom to create, and we never have to worry about the dreaded algorithm. TierZoo and I are actually competing to see who can get more signups. Please don't make me look bad in front of TierZoo. But seriously, we put a lot of work into this. We are really proud of the result. It's a place where creators can do what they do best, create. It's a place where we can both house content ad-free and also experiment with new original series that probably wouldn't work on YouTube, including an exclusive series called Working Titles, where every episode, a different creator breaks down their favorite TV intro sequence. Polyphonic did Game of Thrones, Patrick Willems did X-Men, and I'll be covering Law & Order very soon. So what does this have to do with CuriosityStream? Well, they love educational content and educational creators, so they are the perfect partner for Nebula. We recently just worked out a deal where if you sign up for CuriosityStream using the link in the description, not only will you get a 1-month free trial for CuriosityStream, but you'll also get a Nebula subscription for free. And to be clear, that Nebula subscription is not a trial. It's free for as long as you are a CuriosityStream member, which means that for less than $20 a year, not only do you get unlimited access to CuriosityStream's massive library of gorgeous high-budget documentaries, you'll also get to enjoy the private playground for YouTube's best educators for no additional charge. And you'll be supporting the creators, like me, directly. It's a win-win. Win-win. Win. So if you click on the link in the description, not only will you be able to access CuriosityStream's amazing documentaries like Bright Now, which is a fantastic deep dive into timely stories about global issues, but you'll also get a subscription to Nebula, the platform made by creators for creators. So click on the link and check it out. I promise you won't be disappointed. So, do you agree with my grade? Leave your objections in the comments, and check out my other legal reactions over here, where I will see you in court.